All right, folks, we haven't taken a deep dive into the Jeffrey Epstein stuff here at the Katie Phang News Channel until today. And I feel like the timing actually is good for us. Why? Because now we have this total Donald Trump head fake move where Pamela Joe has made a motion to unseal records. And we're going to get into that filing in a second, but I really wanted to make sure that you guys understood the full kind of universe of facts and issues from a legal lens so you can understand why convicted felon Donald Trump's claim that he's seeking transparency on these Epstein files is a crock of bullshit and is purely a self-preservation move by Trump in a legal and political sense. But let's get into it. Alrighty. Let's start with this first document. It's the actual memorandum that was released by Pamela Joe Bondi on behalf of the Department of Justice and purportedly by the FBI, Kash Patel. Alrighty. And if for those of you that haven't had the chance to actually look at the memo, go and check it out. It's not very long, page and a half, not even. And we're going to go through some of the more highlighted kind of issues in this memorandum. It was released on July 6, 2025. And as we sit here, it is July 21st. So there's been about 15 days since this memo came out. And the memo is so kind of pat me on the back, self-congratulatory about all the hard work that was done. But ironically, these claims about being exhaustive and the significant amount of material and the work that was done by the FBI in this instance, it's going to come back to bite them in the ass. Because if it was so exhaustive and significant, and if it was a part of their commitment to transparency, as they put in this memo, then there should be stuff that should be and can be released to the American public. So again, according to this memorandum, the FBI conducted, quote, digital searches of its databases, hard drives, and network drives, as well as physical searches of squad areas, locked cabinets, desk closets, and other areas where responsive material may have been stored, period, end quote. That's a lot of places to look for this, quote, responsive material. And according to this memo, these searches uncovered, quote, a significant amount of material, including more than 300 gigabytes of data and physical evidence, period. Not my words, Pamela Joe's. Okay, so as we sit here today, again, 15 days later, still don't have anything that has been released to the public at all, other than the video manipulated, sliced together. We'll get to that in a second. And by the way, I agree with the following statement that was made in this memo. Only a fraction of this material would have been aired publicly had Epstein gone to trial, as the court-ordered seal on these materials served only to protect victims and did not expose any additional third parties to allegations of illegal wrongdoing. Okay, wait, so I'm going to self-correct right now. I agree that a fraction of this material would have been aired publicly had Epstein gone to trial. I do not agree that these materials did not expose additional third parties to allegations of illegal wrongdoing. On its face, that cannot be true. On its face, that cannot be true. There were, according to this memorandum, more than 1,000 victims. How can you possibly, with a straight face, tell the American people that if Epstein was a party to the abuse, criminal conduct against more than 1,000 victims, that none of the material that has been uncovered by the FBI vis-a-vis Epstein exposes any additional third parties to allegations of illegal wrongdoing? That in it of itself is impossible, not possible. Based upon this self-serving statement, Bondi then says, we found no basis to revisit the disclosure of those materials and will not permit the release of child pornography. No one wants to see child pornography. No one wants the release of child pornography. That is not what is being asked for here. Everybody, in the interest of the transparency that this administration ran a campaign on, Trump ran a campaign on transparency, especially considering the Epstein files. No one wants the release of child pornography. Nobody wants to re-victimize the victims in this case, according to the FBI, the more than 1,000 victims. So whatever comes out must be appropriately sealed, redacted, etc., to protect the victims and the vulnerable. That is a given. But to suggest that there's literally nothing else to be released, I submit is a lie. Okay. Here's the other outrageous line in this memo. Perpetuating unfounded theories about Epstein serves neither of the ends, meaning combating child exploitation and bringing justice to victims. I think bringing justice to victims is actually really important in this instance. We always have to go back to the victims in these cases, and to not forget them, and to understand that they were truly victims at the hands of Epstein, Maxwell, and others. And it's the and others part that's the most important part of this analysis. But the fact that Bondi, Patel, Bongino, any of these people are saying that perpetuating unfounded theories is wrong. I mean, they clearly don't own mirrors, because they clearly have never had the self-assessment to understand and the self-awareness to understand that all they've done is perpetuate unfounded conspiracy theories for years. Bondi, when it comes to, at a minimum, the election denier bullshit, and clearly Patel and Bongino have staked their career, almost like their careers, on this Epstein file bullshit, right? And not the crimes that are bullshit. This idea that this has only been a Democratic thing, and it's only been controlled by the Democrats, and it was only perpetuated at the hands of the Democrats. It is the determination of the Department of Justice and the Federal Bureau of Investigation that no further disclosure would be appropriate or warranted. Again, that is not true. And then we get into this idea, Epstein committed suicide, that conclusion is supported by the video footage from the common area of the special housing unit where Epstein was housed at the time of his death. The FBI enhanced the relevant footage. The full, raw, and enhanced videos are available at the following links. Of course, nowhere does Pamela Joe say that there's missing portions of one of the clips, that they stuck the clips together, and that the, quote, full raw footage is really not the full raw footage. This is the top cop of the United States, I want you to understand, and the top other investigator, which is Patel. I mean, and if that's the case, and this is what they think is supposed to be okay, they're wrong. So let's move on to the next document. So we know that Trump announced in one of his Truth Social posts on Thursday of last week that he had authorized Pamela Joe to, quote, produce any and all pertinent grand jury testimony, comma, subject to court approval, period, end quote. Well, you and I both know that he didn't write that without some help. And you and I both know that the adjective pertinent in that Truth Social post, that is doing some heavy lifting. What's pertinent, convicted felon Donald Trump? What's pertinent to you? The part that doesn't include you? Is that what you call pertinent? Is the only pertinent part the part that deals with Democrats only? What's pertinent? If we're going for full transparency, America, then you need to release all of it, not the parts that are, quote, pertinent. And funny, you want the testimony subject to court's approval? We're going to get into why grand jury testimony is going to be not a lot and limited in this instance, but subject to court approval? Of course it's subject to court approval. Grand juries are cloaked in secrecy and confidentiality. That is a given. That is given under the law. That is a given under the rules of criminal procedure. But this is the head fake, people. This is the punt by Donald Trump to blame federal judges. Ooh, gosh forbid they're actually nominated and appointed by Democrats, right? Because then it's just going to be more of the hoax, fake news, conspiracy, right? But Trump is punting this to the federal judges. He's setting this up so that he can blame federal judges for them not, quote, releasing the grand jury testimony. But that's not going to be the case. Meaning, if the grand jury testimony isn't released, that's not going to be the fault of the judges. You understand? Alrighty. Here's some other stuff. Pamela Joe has agreed to release some materials that were already publicly available. Thank you for no favors. Thank you, Pamela Joe, for no favors. Flight logs, information like that. Okay. Publicly available doesn't help us. Publicly available means exactly that. We've had it. What is the stuff that people haven't been able to access and see? All right. So let's go to the motion itself. I think it's really important that we actually go to the motion. So let's go to the motion. This motion was filed on July 18th. This was Friday, filed late in the day. And it's a half-assed motion, if I may say so, as a lawyer. Don't just play one on TV. It's entitled United States Motion to Unseal Grand Jury Transcripts. And it's been filed not only in the Southern District of New York, but I want to be clear, it's also been filed in the Southern District of Florida, and it's also been filed in the Southern District of New York in Ghislaine Maxwell's case. So let's be clear. It's the Jeffrey Epstein case judge, it's the Ghislaine Maxwell case judge, and it's the Southern District of Florida judge who would be dealing with the portions of the grand jury that was down in South Florida, down in my area of the world. So the motion to unseal, I also welcome you to review this. It's only 3.5 pages long. It's really not complicated at all. And again, does a victory lap saying this was this exhaustive review of all of the information. And it uses the phrase extensive public interest a lot, because that is what the DOJ is relying upon as the justifiable basis to unseal these records, that there's extensive public interest. But we're lawyers here, aren't we? We are lawyers here at the Katie Phang News Channel. So let's break down legally what's happening here. The motion is seeking relief from the court. And what are they seeking? They want the court to unseal the underlying grand jury transcripts. I'm going to live and die, and my Alamo will be the word transcripts here. Because transcripts, as they suggest, are literally the taking down by a court reporter of every word that is said verbatim during the course of these grand jury proceedings. Now, of course, there's going to be something of value there. I will not dispute that the transcripts themselves will not have value. But this idea that the only thing being sought to be released, and again, subject to court approval at this time, are the transcripts only, that is a crock of shit. Okay, so in the motion, they want the grand jury transcripts released subject to appropriate redactions of victim-related and other personal identifying information. Great, we're all in agreement with that. And then it walks through that there's a grand jury that sat and charged Epstein, and then there's a grand jury that sat and charged Ghislaine Maxwell. Remember, the Maxwell stuff is important. Why? Because she went to trial, she was convicted, she was sentenced. She has appealed her conviction and sentencing to the Second Circuit Court of Appeals that affirmed her conviction and sentence. And she's now pending an appeal before the United States Supreme Court, as in she's asking the Supreme Court to take up her appeal. This current DOJ, the Pamela Jo DOJ, has objected to the relief that she's seeking. But remember, this is an active case. So of course, the Bondi DOJ, the Trump DOJ, knows that there's a pending request for the Supreme Court to take this case. That's why when you're asking the Ghislaine Maxwell judge to release and unseal the grand jury transcripts, of course, we already know the judge is going to say no. So please, people, when you're having this conversation with people, do not let yourself be gaslit, and do not let them be gaslit into thinking that this is some type of move towards transparency by Donald Trump and the Pamela Jo Bondi DOJ. It is not. We all know, she knows, Trump knows that at a minimum, the Ghislaine Maxwell judge is not going to release these grand jury transcripts. At a minimum. Alrighty. Now, let's go to the rest of the book, because we're in law school again, so pull on up, people. Ready? Here we go. Quote, paragraph 4, page 3. It's a tradition of law that proceedings before a grand jury shall generally remain secret. Thank you. The tradition of secrecy, however, is not absolute. Although rule, and this is all quotes, by the way, and y'all see this on your screen, although Rule 6B3 of the Federal Rules of Criminal Procedure generally lists exceptions to grand jury secrecy, the Second Circuit has recognized that there are certain special circumstances in which the release of grand jury records is appropriate, even outside the boundaries of the rule. Citing to a case in Ray Craig from 1997 in the Second Circuit. Okay, so what does this mean? Well, first and foremost, the DOJ and their half-ass motion don't even cite to the proper rule of criminal procedure. Rule 6, Federal Rules of Criminal Procedure, 6B3, number 1, 6B3 doesn't exist. So, gosh, maybe we should actually cite to the right rule of federal criminal procedure, Department of Justice. Oh, wait, do you want to know who signed it? You know, we always go and look, right? Oh, Pamela Jo Bondi, signed by Todd Blanche. Alrighty, so let's go to the rule. Now, unless otherwise, provided otherwise, you don't disclose anything from a grand jury. But let's go to the exceptions. And the exceptions are the ones to go to. The exceptions start at 3. And if you go to 3, so it's really 6E3, people, by the way, as in Rule 6E sub 3. Okay, but anyway, so you go to 3. And we look at the exceptions, and you know what? What did they say? Extensive public interest is not listed as one of the exceptions. Just letting you know. So, not here. Okay. Not here. Now, is it within judicial discretion to release grand jury records? Yes. Yes, they are. Okay. So, because of that, what does the motion say? Quote, public officials, lawmakers, pundits, and ordinary citizens remain deeply interested and concerned about the Epstein matter. After all, Jeffrey Epstein is the most infamous pedophile in American history. The facts surrounding Epstein's case tell a tale of national disgrace. The guy that Trump was buddy-buddy with, right? That's the most infamous pedophile in American history, right? Now, the law in the Second Circuit says that special circumstances can include historical interest by the public. I think historical is also doing a little bit of a heavy lift there, but the court retains discretion to determine whether such an interest outweighs the countervailing interest in privacy and secrecy. Of course, in this instance, they're saying that because Epstein's dead, the privacy interests on the other side are substantially diminished. And then they say the court should conclude that the Epstein and Maxwell cases qualify as a matter of public interest, release the associated grand jury transcripts, and lift any pre-existing protective orders. That's the motion. Yeah, Epstein's dead. Maxwell's not. And more importantly, this case is not 100 years old. This case doesn't have historical kind of age on it. Some of the victims are still alive. So there is right now, the factors militate towards not disclosing these grand jury records. And again, Bondi knows this, Trump knows this. So this head fake of trying to ask the court to do this is not a move towards transparency by Trump. Let's go back to the rule of criminal procedure because this is important. Alrighty, it says here the following. It says here, and let's go back to the rule because the rule is important. A petition to disclose a grand jury matter must be filed in the district where the grand jury convenes. So that's why we see the two grand juries. You got the Southern District of New York, and then you have the one down in Florida, right? Unless the hearing is ex parte, meaning it's being done without notice to the other side, the court must afford a reasonable opportunity to appear and be heard to an attorney for the government, the parties to the judicial proceeding, and any other person whom the court may designate. That probably means that, assuming this even gets past the point of a judge even thinking about releasing this stuff, that it may be the case that the court may designate the people that are impacted by these records, like the victims in this case, be given the opportunity to be heard if they choose. And these things are kept under seal as long as necessary. Literally, it says here that these records are kept under seal to the extent and as long as necessary to prevent the unauthorized disclosure of a matter occurring before a grand jury. It all leans towards not disclosing. So, making this big dog and pony show about trying to unseal these grand jury transcripts is not a move that is going to be a successful one. And again, Trump is only going to use this as an excuse to blame the federal judges in this case for failing to disclose them, saying, look, I went for total transparency. It's not my fault. And yet the grand jury transcripts are not going to have the value that Trump and Bondi want you, maybe not you because you're smart enough to know this, but the MAGA land and American public to believe. First of all, grand jury presentations are intentionally brief. When we used to present to a grand jury, of course, we're not going to put all of our cards on the table. A grand jury is sitting for the purposes of determining whether or not to return a true bill or an indictment against a criminal defendant. I am only going to present as a prosecutor the minimal amount of information that I have to present in order to obtain that indictment. Why do I need to put my entire case in chief out on display? I do not have to do that. I do not have to do that. There's a reason why there is that old adage, you know, you can indict a ham sandwich. I mean, I'm not saying, and I'm not trying to be flippant, let me be very clear. As a former prosecutor, we take these responsibilities very in a grave sense, right? It's very important. We wield so much power. But when you're in front of a grand jury, you're not going to put all of your cards on the table. So with these grand jury transcripts are not going to be long transcripts, number one. And then number two, especially in the Southern District of New York, and don't take my word for it. I mean, there are media upon media articles that have interviewed former Southern District of New York prosecutors that have said the following. It's normally just the presentation of a federal agent, and I said this last week on Substack Live and otherwise. It's a federal agent who can sit down and say, during the course of my investigation, I interviewed the following victims, and this is what they told me about the criminal defendant. So what you use is you put a very good federal agent up on the stand. And under oath, they provide this testimony to the grand jurors. And that's kind of like the vehicle by which you're providing this information to the grand jurors. You're not going to have to sit there and have a parade of witnesses coming through, especially in the Southern District of New York. So even if Bondi is successful in getting an order from a judge unsealing the grand jury transcripts, not only is it going to be heavily redacted to protect the victims and the vulnerable, but you're only going to be hearing it through the lens of one voice. And that's going to be one, maybe two federal agents that were a part of this investigation. Okay, number one. Number two, and again, for example, if you look at this article from the Associated Press from yesterday, they spoke to a number of former Manhattan federal prosecutors who said, it's not going to be everything the FBI and the investigators have figured out about Maxwell and Epstein. The transcripts at most, one says, probably as little as 60 pages. Why? Because the Southern District of New York's practice is to put as little information as possible into the grand jury. And they all agree with me too. Grand jury witnesses are usually federal agents summarizing their witness interviews. I mean, hello. That's not going to be a lot of information that's going to come out in these grand jury transcripts. You know what is something that could be released by Pamela Joe? These things called the FBI's 302s. 302s are like the forms that summarize witness testimonies that can be sent out and given to the American public, redacted. Texts, videos, photographs, emails, documents that have been redacted, again, to protect the victims and the vulnerable, that could be released, and the American public could see that. It's not just the grand jury transcripts that have value when it comes to this idea of the pursuit of transparency. Now, here's the other issue that I wanted to talk about with you. So there were, in this instance as well, several search warrants, right? So search warrants are not grand jury warrants or subpoenas, excuse me. They're not grand jury subpoenas. So search warrants in this instance are really important too. So a search warrant is based on probable cause, right? That fruits of the crime are going to be located in a particular place, and it's got to be identified with specificity. And there's a whole bunch of Fourth Amendment law that deals with the legalities of searches and seizures pursuant to a search warrant. But a search warrant was executed on the Epstein properties, and those search warrants reveal fruits of his crimes, can implicate others, including Ghislaine Maxwell and others, and that information can be given to the American people, again, subject to appropriate redactions. I'm not quite sure why. Well, I take that back. I know why. Trump seems to think that this grand jury transcript thing is going to be the universe of information to be given to the American people. It's actually one of the hardest things to get through. Not only is there legal precedent to stop this from happening, but we also know it's not in the end going to have a lot of evidentiary value. People, focus on the ball. Do not get distracted by this idea that this grand jury motion is going to have a lot of value. The likelihood of a ruling anytime soon by a judge is slim to none. We're not going to have this information in terms of a ruling from the judge for a long time. And number two, even if it is granted, it's going to be so heavily redacted, we're probably not going to see a lot. And then number three, even if it's unsealed, it's not going to be a lot, period, end of story. Pamela Joe at the DOJ, Kash Patel at the FBI, Dan Bingo Boingo Bongino at the FBI, these people, Todd Blanche at the DOJ, they have their ability to be able to release more information, and they were refusing to do so. But you know what? Even though I don't like them, I'm not going to blame them. I'm blaming Donald Trump. They are doing this at the behest of their dear Führer, and there's a reason why you're not getting this information. So again, when you talk about this, number one, share this video. Share this video far and wide so people understand the legal implications behind this motion that was filed by the Department of Justice on Friday. And so that people understand, legally speaking, why what has happened is just a political and legal head fake by convicted felon Donald Trump. That there is nothing that they have offered in this motion that was half-assed drafted that is given real justification to be able to unseal this. And look, I am happy to eat crow if I am wrong. And these grand jury transcripts at a minimum are unsealed. But I also know enough, having practiced law for more than 25 years, that what's going to come out is really not going to have the value of what it's supposed to be. And it never should be enough to satiate. The last thing I'm going to say before I sign off from you guys is this. When I say be mad, be outraged, demand accountability, I'm doing this in this context for the victims of Jeffrey Epstein, Ghislaine Maxwell, and others. The indictments victims in this case allege that there were others that were involved in this case. I don't care if they're Republicans or Democrats, they should be held to account. They should have to face justice. And I am doing this because the victims in this case deserve justice. So be mad and be outraged and demand accountability for the victims of Epstein and others, and demand transparency on these Epstein files, and do not stand for the bullshit of thinking that this grand jury motion really has any weight towards transparency when it comes to this administration. I'll see you on the other side. Katie Phang here. We launched the Katie Phang News Channel in partnership with the Midas Touch Network so we could bring you the latest in legal and political news. Straight, no chaser. So if you're a fellow truth teller, hit that subscribe button and share the word about this channel so we can build a high information America together.